What's up, everybody? It's Stephen Williams, founder and president of the creditrepairshop.com. Got my notes right here. And in today's video, we're going to talk about debt being sold on the market. There's some new batches that just came out late last night. I'm going to answer some YouTube questions, some very good ones that came from the comments here on YouTube. And we're going to talk about visualization. And because I believe that that's important. That's what makes this channel different. That's what's going to make things happen for you, because I believe and I know good things are going to happen for you. Just believe that they will happen. Don't focus on the negative. And you know how we always start the videos also. Please like them. You know that I'm giving you great content that you're not going to really be getting from any other channels, at least that I know about. So please like the video, please subscribe, please get notified of any new videos that I have coming out. So let's first start with the debt being sold on the market. This portfolio is for $9 million, total $9 million and some change. Average balance over $4,000 for each balance. It's a mixture of major credit cards. Selling the whole thing for $2,500. This is national, all 50 states. Charge-off date 2007. So you already know what the solution is. If you get one of these debts, you need to look on your credit reports. If you get anything from any major credit card company that you had an old debt that was longer than 2007. Older than 2007, these are 100% past statute of limitations. So if you get it, you don't need to validate the debt. All you need to do is notify them that according to the laws in your state that is past the statute of limitation for contract law, and that you request that they cease and desist all collection activities, and that you will be reporting them to the proper authorities in your state. Proper authorities in your state is Department of Financial Institution. That's who regulates debt collectors in my state. Or you can look up who regulates debt collectors in your state, and also the state attorney general's office. That's all you got to do. Don't get into any back and forth with them on the phone. You need to do this in writing. You need to send it certified, so you have proof that you notified them that you're, number one, disputing the debt, and that you're putting on record that it's past statute of limitations to even be collected, regardless of the debt that you owe the debt. And then another way that you can look is to make sure that it's past statute of limitations, and that you didn't accidentally make a payment or something that reauthorized the debt, is you need to look at your credit reports and look at the original charge-off or write-off date for that debt. Again, get your credit reports, not the free ones, because the free ones is just a trap. You need to get a paid monitoring service so you can see all of the data. Look in the comment section, or look at that account and look at the original charge-off or written off date. That's how you'll know if it's past statute of limitations. This is for 2007. The longest statute of limitations state, 3 states, is 10 years. So it's 100% past statute of limitations for all 50 states. So that's all you would have to do. And if you don't have your credit reports, you can go to the website that I put here on the screen. It's your3scores.com. We got another group of major credit cards, major banks, $3.97 million, average account a little over $2,500. They're selling it for $5,000. Charge-off date was 2011. So with only the 3 states that have a 10-year, and I'll get that for you real quick so you don't have to guess in my little manual here. The 3 years that the 3 states that have it the longest, there's more than 3 states, but here, let's just go over it real quick. For contract law, we have Louisiana, Sorry about that. Make sure it's still recording. We have Louisiana. We have Missouri. I'm sorry, take that back for Missouri. So we have Louisiana, 10 years for written contract. We have South Carolina, 10 year. And let's see here. I thought there was someone else. So it is only, oh, and then Rhode Island, 15 years. Rhode Island, 15 years. So I told you there's only 3 states that have it, so I take that back, that Rhode Island, if you happen to live in Rhode Island, 15 years. You got 15 years that, so if you receive one of these and you live in Rhode Island, you still have some time. If you live in any other state, it's past statute of limitations. We have another group here, Payday Loan. Not going to mention the company. Average account, $1,900. $800,000, 409 accounts. It is all 50 states. They have another group of them for $1.1 million. They're selling it for $4,000. Average charge off 2014. The other one charge off is 2014. So you'll need to look in, if you get something back from either major credit card company or a payday lender, well-known national payday lender. You need to look first if it's past statute of limitations. If it's not past statute of limitations, you need to do a validation of the debt. And when you do the validation of the debt, you need to get the relationship between you and that company. You also need to look on your credit reports to see if that debt was canceled. If it was canceled and it was accidentally put into these accounts, because these are hundreds and thousands of accounts. This one here had 1,200 accounts, and this other one had 1,800 accounts. They can accidentally slip your account in there, even though it was canceled, and you end up paying for a debt or having them put that on your credit reports when it's not even legal to be put on your credit reports. Please refer to my other videos about canceled debt. Please refer to my other videos about doing a debt validation. Now let's get into some questions that was asked from some YouTubers here. We got one said that they had a judgment from 2017. They did not get notified, or they don't remember being notified. And also on their credit reports, it showed that the debt was canceled. So this debt is actually illegal to be collected. What probably happened is that a debt collector bought the debt, sent a summons to the last known address, and that's all they have to do. They don't have to give it to you. They can send it to the last known address, go to court, say that they attempted to serve, and the judge, if you're not there, they're going to give them a default judgment. So this was a default judgment. Depending on your state, you may be able to reopen the case. In my state, you would not be able to reopen. You only have 6 months to reopen, even if it's a default judgment and you were not notified. If you can prove, there's certain circumstances that if you want to fight it, that you can try to say that you were not notified. But in most cases, they're going to say that all they had to do was serve it to your last address, and you have 6 months, because they're going to publish it in the newspaper. That's all they have to do. They don't have to go overboard with it. They just have to prove that they serviced you, post it in the daily paper or a weekly newspaper. And if you don't see it, tough luck. That's all they have to do. So, but it shows that the debt was canceled. So you do have an argument to where you can go to court, ask for it to be reopened, and tell the judge that this judgment was made under false evidence, and that you want this whole thing to be thrown out. And you also potentially could have a lawsuit, because if they file that and you can prove that they did know that it was canceled, or if no matter what, you're going to have a lawsuit either with the original creditor or the debt collection company, because they cannot collect on a canceled debt. Something that you need to look up, and you can contact the IRS to get this, is that if you had that 1099-C debt cancellation form from the IRS, or that they sent to the IRS, when you go into court or you send that to the judge, that will be enough evidence to prove that this was a false judgment. Now, they might want to say, well, was it canceled after or canceled before? If it was canceled by the debt collector, then the judgment does not stand. If it was canceled by the debt collector. So you got to watch out on this, because it maybe was canceled by the debt collector and not canceled by the original creditor. Another YouTuber asked a question about settling debts at a discount, and please like the video. Please like, notify, and subscribe to the channel if you haven't subscribed to it yet. Really appreciate it. Can you get a discount on settlements? The way that it always works is you ask them first you ask them, tell them that you want to submit a settlement offer. You need to make sure the amount that you have available to settle, and then you always back off of that. So, for example, let's just say that the debt is $2,000. Start it like $100 or $200. I know that might sound crazy, but do that and then start working back and forth with them. Now, I can let you know that these are some of the things that might make it to where the debt cannot be settled for that small amount. If it was not purchased and they're just hired by the original creditor, you're not going to be able to settle the debt potentially at that amount, because they're going to tell the debt collection company that's handling the account for them the maximum amount that they would want to settle. What we've been seeing is 40 to 50%. Anything after that, lower than that, you're going to probably have to do financials to prove a hardship. But you can do it. With these debts here, they're buying them for pennies on the dollar. If they purchase the debt, usually what's going to happen is the debt collection company is going to want you to fill out a financial statement and to see if you have a true hardship. And also it's going to work within how much of their money that they've made back. How much have they invested in getting money? So to give you an example, to break it down, with a debt collector, what they're going to do if they have 409 accounts, what they're going to do is they're going to invest money, number one, to mail out to people to the first letter saying that you owe this debt and that when are you going to pay it. Then from all of the people that don't respond to that letter, they're going to go to their credit reports and they're going to look up and try to see if that person is working. They're going to try to get as much data as possible, and that costs money. It costs time to have an employee do it, and money because you're a member of the credit bureaus of all three. That's three different bureaus. And also they're going to have to look up on Pacer to see if you file bankruptcy. They got to look up all of that. So that's going to be manpower hours that they got to pay someone to do. Next step is, if they decide to, they're going to take you to court. And to take you to court, at least in my area, they're going to pay upwards of $75 per to send that to court. So we got $75 times 409. So that's $30,000 that they're investing. So if you're one of the first people that respond back, and your account for like these accounts was $1,900, they're really not going to try to go down much at the beginning. They're going to push hard to try to get that $30,000 back plus whatever they spent in man hours. So what I've seen the companies usually do is they're gonna try to take people to court, and then they're gonna try to get a default judgment, and then try to move that over to doing garnishments, because this is where they can get 100% of the money, and they can have all of these payments coming in from all of these different accounts. That's what they're going to try to do. But uh, they do try to hurry up and make that 30 grand back. So that is a time that you can push hard to try to do a settlement, but they may not go as low as they would go if they've made that money back and now everything is going to be gravy on top. Another question someone had was they need to go to court, and should they have an attorney with them? And I'm not going to give you legal advice, and I'll make the statement here that all of my videos are for information purposes only. If you need legal help, please consult a qualified attorney or pro se paralegal in your area. If you go to court, what I tell people is that if you don't feel comfortable answering their questions, if you don't feel comfortable asking your own questions, then you probably should. But you might be disappointed when you get in there, because they're going to do what you could have done, and then you're going to be out of that money that you could have used to make a settlement. If you know, I would put it this way: if you know that this is a debt that's not past statute of limitations, and you've done a validation process, which you can ask at that time when you go to court, you can say, well, I'm not sure about this. I would like for them to give me all of the information pertaining to this debt. And you can refer to my videos about doing a debt validation. Get them to do that. Ask the judge for more time. They will allow that. And then once you review it, if it's going to be something that you know you got to pay, then you can contact them and you can try to set up some type of arrangement, and you won't have to pay an attorney to do that. Because if you pay an attorney, you're going to have to pay them to go to court, and even if whatever they get you on the settlement, you're going to have to usually pay 10 or 15% on top of it, and you may be saying, well, I didn't even save any money. But that's up to you. I don't want to tell people what to do on that. I'm not giving you legal advice on that. That's 100% up to you. The next thing is, let's talk about visualization, because when I visualize, I do a visualization treatment every morning, and it seems like it's making more of you come to me and ask me very good questions. It's like renewing me for my business. It's making me even want to do more research and to be able to help more people. So I need this, and I think that you should do visualization. When you do visualization, you should visualize that whatever you're facing, you've already achieved success with it. So if you have debt, or if you have a debt collection or a debt collector that's taking you to court, you have a court summons, I want you to visualize that everything worked out, and then I want you to follow my instructions on what you need to do to answer the court summons. If you have a debt collection and you're going to have to pay it, I want you to follow my directions in my videos to see how you do a debt validation and then get to a solution. But the thing that I want you to always visualize is that you've had the solution that you wanted. And whenever you have the feeling of doubt, I want you to just disregard that. Don't fight the doubt. Don't try to say, where you're going to overcome doubt. No, you just let the doubt be there, and you just back yourself up back to the part that you feel comfortable on, which is visualizing that you're successful. And when it pops up again on how you're going to become successful, you need to back up again and not worry about that part. Don't worry about the how, just visualize that you were successful with what you had to deal with. All right, that's going to end it for today's video. Please subscribe to my channel. If you need help with your credit, visit thecreditrepairshop.com. You need your credit reports and scores, because remember, everything starts there. Go to your3scores.com. Put the link here on the video and also below the video here. Remember to comment, subscribe to the channel, share it with your friends and family. And until next time, this is Stephen Williams, founder and president of thecreditrepairshop.com. Thank you.